A headline is spreading fast: Melania Trump ordered to testify under oath. If that's true, it's not just gossip. In U.S. civil litigation, testify under oath usually means a deposition, recorded sworn testimony that can be used later to challenge credibility, lock in statements, and shape a case. But here's the rule at the brief desk. If a claim is court-ordered, we don't accept vibes, clips, or thumbnails. We accept documents. So tonight we're doing something simple and powerful. We're walking through what the court record actually shows right now and what it does not show. The verified backbone is this. Journalist Michael Wolff filed a lawsuit against Melania Trump in New York State Court in October 2025. On December 29, 2025, the case was removed to federal court in Manhattan, SDNY, under a diversity jurisdiction argument. Then on January 8, 2026, the federal judge issued an order about jurisdiction procedure, what motions can be filed and how. Now the big question, does any of that equal a judge ordering Melania Trump to testify under oath? Based on the primary documents we can verify, the answer is not yet, at least not in the filings and order we can actually point you to. So let's separate what's confirmed, what's unconfirmed, and what would prove it either way. What's confirmed versus unconfirmed, confirmed. The lawsuit exists. AP reported on Wolff's suit and the broader dispute, including the $1 billion figure referenced in the conflict, and Wolff's stated desire to question the Trumps under oath. Confirmed. The case was removed to federal court on December 29th, 2025. That's not a headline. That's a filing. The notice of removal lays out the legal theory. Federal court jurisdiction under 28 U.S.C. paragraph 113.32, diversity jurisdiction, because the parties are claimed to be citizens of different states and the amount in controversy exceeds $75,000. Confirmed. The removal filing includes factual assertions about citizenship and procedural posture, such as arguments about domicile and service. Confirmed. On January 8, 2026, the SDNY judge issued an order responding to a letter about jurisdiction issues, explicitly referencing the plaintiff's ability to move for remand under 28 U.S.C. paragraph 1447C, and the court's responsibility to verify subject matter jurisdiction before ruling on certain motions. Now the viral part. Unconfirmed. A judge ordered Melania Trump to testify under oath. Why unconfirmed? Because the Jan 8 order, the one we can cite, does not order a deposition, does not set a testimony deadline, and does not say Mrs. Trump must testify under oath. It is about jurisdiction and motion practice. Also, the notice of removal does not contain an order compelling testimony. It's a procedural filing explaining why the defendant believes federal jurisdiction exists. So if someone is claiming there's a sworn testimony order, they should be able to show you a signed order or docket entry that says so. What would confirm the viral claim? A filed SDNY order on the docket granting a motion to compel, or a scheduling order that expressly requires a deposition, or an order authorizing discovery that includes sworn testimony from Melania Trump. In federal court, this is typically tied to discovery rules like Rule 30 and court supervision under Rule 26. Let's anchor this story to dates you can verify. October 2025, Wolff's underlying state court filing exists, summons and complaint, showing the case was filed in New York State Court and stating Wolff's claims and theory. December 29, 2025, Melania Trump, as defendant, filed a notice of removal to move the case from New York State Court to the Southern District of New York. The document's core point is jurisdiction. The defendant asserts Florida citizenship and argues the case fits federal diversity jurisdiction. January 8, 2026, Judge Mary Kay Viskachil issues an order noting the court's duty to confirm subject matter jurisdiction, the plaintiff's ability to move for remand under 28 U.S.C. paragraph 1447C, and that the court will act on appropriate motions. This order reads like a judge telling the parties, file the motions and we'll rule, not prepare the deposition. And that's where the verified record stands from the primary documents we can cite here. Everything else, The crisis mode, the forced testimony, the oath order may exist as commentary or speculation, but it needs a document to become a fact. The mechanism, legal explanation. When people say ordered to testify under oath, they're usually talking about a deposition. In federal civil litigation, Rule 30 is the core rule for depositions by oral examination. It explains when depositions may be taken, how they're recorded, and that testimony is given under oath or affirmation. So how does someone actually get forced to testify? There are a few pathways, and the details matter. Normal discovery deposition, common path. If the case proceeds into discovery, a party may notice the deposition of another party, subject to the rules and limits. Rule 30 lays out how depositions work, and Rule 26 governs discovery scope and court management, court involvement, protective orders, limits. If a party argues a deposition is abusive or irrelevant, they may seek court protection. Rule 26 is the framework for the court controlling discovery, including what's proportional and relevant. Compulsion and enforcement. If someone refuses to appear or comply, courts can be asked to compel compliance and impose sanctions, but again, that requires motions and orders. The difference between a party wants a deposition and a court ordered it is a piece of paper signed by a judge. Now here's the nuance that viral videos often flatten. Jurisdiction fights can delay the real discovery. In removed cases, the judge first needs to be satisfied that federal jurisdiction exists. That's why the SDNY order explicitly talks about jurisdiction and remand procedure. If the court ultimately decides it lacks subject matter jurisdiction, 28 U.S.C. Per 1447 says the case shall be remanded. So what about jurisdictional discovery? The idea that there can be limited discovery just to decide jurisdiction facts like domicile. That can happen in some cases, but it's not automatic, and it depends on the judge, the dispute, and the motions filed. Importantly, if a viral claim says jurisdictional discovery was ordered, you still need an order or docket entry that actually says it. What we can verify here, the removal filing makes domicile and citizenship central. The judge's Jan 8 order signals that jurisdiction is front and center and invites proper motion practice. The law provides the mechanism for remand if jurisdiction is lacking. What we cannot verify from the primary documents we have cited, any court order requiring Melania Trump to appear for sworn testimony on a schedule. So if you're watching a clip claiming, the judge confirmed she must testify under oath, your next move is simple. Ask, show me the docket entry, show me the PDF, what's the date, what's the ECF number? If you don't get those, you're not watching court reporting, you're watching storytelling. Key players and incentives. Michael Wolff's incentive. Wolff's lawsuit, as reported by AP, is not just about the merits of speech and threats. It also positions him to use litigation tools and, as he says, question parties under oath. That is a stated goal, and it's part of why under oath keeps appearing in coverage. Melania Trump's incentive. The removal filing signals a strategy focused on jurisdiction and forum. The notice of removal frames Florida domicile as central to diversity jurisdiction. That matters because where the case sits, state versus federal, New York versus potentially elsewhere, can affect procedure, timing, and discovery dynamics. Why both sides care about under oath? Because depositions create records, and records reduce ambiguity. In a dispute driven by competing narratives and reputational stakes, sworn testimony can be powerful, either as accountability or as risk. But the leap from powerful tool to court-ordered right now must be proven by a document. Real-world impact. This is how misinformation grows in legal news. A real lawsuit exists. A procedural move happens, removal to federal court. Someone extrapolates, now discovery will happen, and then upgrades that to, now she must testify, and then upgrades again to, judge ordered it. But courts don't run on upgrades, they run on docket entries. How viewers can verify fast. Look for the case caption and docket, Wolff v. Trump, 125, CV 10752, SDNY. Look for a signed order that explicitly addresses depositions or discovery. Beware of breaking without an ECF document number or PDF. And if you can't access PACER, you can still use publicly mirrored documents like the removal notice and the court order that are already circulating in Citable, like we're doing here. What happens next 3 scenarios? We'll keep this section strictly labeled. Scenario A, most straightforward. Jurisdiction is resolved first, then the case proceeds. The parties litigate, remand, dismiss, transfer issues. If the case stays in federal court, discovery rules apply in the usual way. What would confirm? A written ruling on remand or dismissal motions with a clear statement that the federal court has or lacks jurisdiction. Scenario B, early dismissal or transfer narrows or ends discovery. If a motion to dismiss succeeds early, depositions may never happen. If the case is transferred, discovery may be paused pending transfer. What would confirm? An order granting dismissal, transfer, or a scheduling order staying discovery. Scenario C, the one viral headlines jump to discovery opens and depositions become a battleground. If the case reaches discovery, Wolf could seek a deposition under Rule 30. Melania Trump could seek limits protection under Rule 26. The court could rule on scope, timing, and conditions. What would confirm? A Rule 26 scheduling order opening discovery, or a specific order compelling a deposition setting deposition dates. Notice what's missing from all 3 scenarios: certainty. Court procedure is a chain of if-then, and viral content often edits out the if. Watch list the only things that turn this viral claim into a verified fact: a signed SDNY order that explicitly compels a deposition or sworn testimony. Any remand ruling under 28 U.S.C., Para 14 and 47 clarifying jurisdiction. Any discovery scheduling order under Rule 26 that opens the door to depositions. CTA. If you saw the clip claiming ordered to testify, send the PDF or the docket entry number. We'll verify it against the record. Neutral disclaimer. This explainer does not assume guilt or intent. We report what is documentable, and we label everything else unconfirmed until primary sources prove it.